Good afternoon, everybody. I'd like to begin by acknowledging that we are on Ngunnawal, Ngarigu lands and their various family groups, to thank them for the care that they've taken for this land, and made this a place of learning and cared for all its denizens, inhabitants, the environment for tens of thousands of years. I would also like to acknowledge other Aboriginal people in the audience, friends, colleagues. My ancestry is from the Western Torres Straits, the Creole-speaking group, but I was born and raised on the mainland on Wik territory on a mission, but fortunately for me, the Wik women who raised us, servants, slaves, domestics, call them what you want, were the most beautiful people who gave us, perhaps in absence of the love of our parents, a kind of love that is known only to the oldest civilizations in the world. The Wik people and Aboriginal people in general are the most generous, most beautiful people you can imagine on this planet. They had the longest civilization, continuous civilization, and as an islander man myself, I tell myself that I can learn from them, and I put to you that we can all learn from these beautiful people. I would like to thank Bluestar for inviting me to speak today on this issue. And the elders of the various faith communities and the diplomatic corps. The topic I'm going to talk to you about is about constitutional recognition. But let me say at the outset that what recognition is seeking to do is to undo huge injustice. This is the starting point. It's like adding a drop of warm water into the Antarctic. There is so much injustice in the past. The question is, what can you do to help overcome these problems? And I guess the approach that I take, and I know there are many, many different Aboriginal views on this issue, is perhaps purely a legalistic perspective, and that is, what can we do within the law? And I put to you, and though I'm a lawyer and I'm an officer of the court, I'm speaking as an individual, and I say that this law is not just. It has never been just to my people or the other nations that make up the Aboriginal communities of Australia. The structure of my talk, to do this, I'll talk a little bit about the history of where the constitutional issues arise, primarily, the history leading up to the creation of the Constitution, and the evolution of the engagement of Anglo-Australian legal traditions with Aboriginal people along the way, leading up to what we hope in 2017 or perhaps 2018 would be some kind of legal recognition. And legal recognition is, at law, a simple thing that says, I see you. That's what it is. And while it's a small step, it's taken over 200 years for Anglo-Australia to even be able to think about this. And this comes to the point of Aboriginal invisibility in our mainstream society. We talk about multiculturalism and all of these different kinds of terms as if they were new. There were 500 nations with 500 different languages coexisting on this beautiful land of ours, the land that we have to care for, the land that nurtured us, that nurtured our ancestors. This is not new to Aboriginal people. There were no real conflicts between these people. People travelled for trade, for marriage, for all sorts of things along the song lines. So talking about working together and living together is not new to Aboriginal people. My appeal is not to Aboriginal people. Talk to any Aboriginal person and they can tell you a lot more about this stuff, and it'll take them years to do because they have thousands of years of history behind them in what they bring to you. But in terms of the Anglo-Australian law, recognition in the Constitution requires the Constitution itself to be satisfied. Now, this is very circular. Section 126 of the Australian Constitution says that for a change to occur in the Constitution, you need a double majority. A majority of the people, the majority of the voters, in a majority of the states. Now, Aboriginal people are not a majority either in the country. Aboriginal people make up maybe 2.5% of the voting population, maybe 3% of the population at best. And the majority of the states and Aboriginal people don't even come close to being a majority in any one of the 6 states. So whatever is decided in 2017 or 2018 will hugely impact on Aboriginal people, but it is somebody else who's deciding this for us. So, we are trying to cure an injustice, and we are appealing to other people to do this for us. Law makes us do this. We don't need people to tell us how to live. We don't need people to tell us how to behave. We don't need people to tell us how to care for country. But this is what Anglo-Australian law does to us. And if you think that we are now, in most instances, a fabulous society, you look around the world and we are one of the better societies, you can just imagine what it was like for Aboriginal people in times when Australia was not such a wonderful society. Of course, the way we treat, say, refugees or asylum seekers shows us the capacity of our society for cruelty. And while the gaze has moved away from Aboriginal people to some other group, I think most Aboriginal people will say, we don't want injustice on our mob and we don't want injustice on any other mob. We've never done that in the past, and nothing people bring to our beautiful land will make us behave that way. We will continue to live as civilized people as we have always done. So what is the history of where we are at the moment? I would actually like to acknowledge Sharon Payne, who's a fabulous lawyer here, and sister, please, let us know if you would like to add something to the I do. When the English first arrived, some of the historical material we have shows that there was actually quite friendly engagement between the two groups. And one of our PhD students at the ANU is going through some of the material from Victoria, where the history written up about Aboriginal people says about the Victorian Aboriginal people pretty much what I said to you: beautiful, civilized, clean, hospitable, generous people who knew the land and who wouldn't let a dog go hungry if they were hungry around. So this is not us praising ourselves. Self-praise is no praise, but this is from other people who've said that. However, with the competition for land and for competition for resources, and trying to understand the other side of it, Englishmen 12,000 miles away from their home, perhaps feeling lonely and afraid. So it's difficult to judge people from a different generation. It's hard to project our minds back. But there were huge conflicts, and the law treated Aboriginal people either as inferior, vermin, or invisible. and the death of an Aboriginal person accounted for very little in the law at that time. Formally, the first case that considered Aboriginal people was Cooper and Stewart. Again, the way in which Aboriginal people become part of the case is indicative of Aboriginal invisibility in the eyes of the colonial powers. So Cooper and Stewart was a case in New South Wales, as we know today, and I mean New South Wales was much bigger at the time, included Victoria, Tasmania and Queensland, but New South Wales of the time, but also New South Wales as it is today. A gentleman was given 40 acres of land by the governor, and he did whatever he did. He cleared the trees and was planting stuff. The governor, however, about 10 years down the track, wanted to resume 7 acres of this land to build a public amenity, and the gentleman in question refused to surrender the land. And the governor said, well, it was given to you out of the grace of Her Majesty the Queen, and therefore Her Majesty has the right to recover these 7 acres. The gentleman in question said that he had discussed the acquisition of the land with the Aboriginal people of the Eora Nation, and that the Aboriginal group that was on that particular parcel of land had given him authority and the right to continue to raise his family and continue the activities he'd been doing. The courts in New South Wales refused to accept this, and the case was appealed all the way to the Privy Council. And the Privy Council, their lordship, said the Aboriginal people have no right to the land. They are not the owners of the land, and therefore do not have the right to alienate this land to a white person or anybody else. And therefore it's the governor's rule, the governor of New South Wales, who is the true custodian of the land and can alienate the land as he wills. So you can see this is the view of the Privy Council. These are invisible people. They don't exist. This is terra nullius. It's an empty land. It is land, if occupied by a previous people, a people who didn't cultivate a yard of land. And this was the test at international law for the acquisition of an empty tract of land. So here begins in the law the invisibility of Aboriginal people. We move on to the turn of the century, when the 6 colonies, for their own reasons, want to unite into a federation and have a series of constitutional conventions to bring together a founding document that would be the basis for the setting up of this Commonwealth of Australia. And during the constitutional conventions, they discussed many things, as you can imagine, a parliament, a senate, interstate trade, lighthouses, marriage and divorce, as many things as you can. And the way the constitution was set up was that plenary powers were left with the colonies or the states as they were to become states, and the residual powers or enumerated powers were vested in the federal government. Now, in this document, Aboriginal people were invisible to the law, but they were not invisible to the Constitution itself. Section 117 of the Constitution said, for the reckoning of the number of people on the continent, Aboriginal natives shall not be counted. So, they are not human beings, they are not people as the Constitution understood them. They were to be regulated under the Flora and Fauna Acts. I mean, if this is civilization, I don't want to be civilized. I'd remain the way I was, happily. The other section, Section 25, recognized that there were people other than the Anglo-Celtic, Norman, Cornish group on the continent, and wanted to create laws to enable the Parliament to discriminate against them. So they were, the states were able to exclude these people from voting, for example. One of the main powers referred to the Commonwealth was Section 5126 of the Constitution, which allowed the federal parliament to make laws, differential laws, with respect to people of a race. And this meant non-Northern European races, because they didn't see people as these people as a people of a race. But mainly the Afghans, the Syrian hawkers, the Japanese gold miners, the Malay pearl divers, and the Japanese who were in Australia, plus Kanaks and people from Vanuatu and the South Sea Islands who were brought in as slaves to work on various projects. But what the Commonwealth was clearly excluded from was making laws with respect to Aboriginal natives. So it clearly didn't allow them to do that. And the history in the constitutional conventions is that the power that was vested with the federal government was to allow the Commonwealth to deport these people and hence make Australia more white. So any coloured people were to be sent back or repatriated to their countries of origin, but of course they had nowhere to send Aboriginal people, and according to the Constitution, these were not people anywhere. And the theory at the time was that this was a dying race, and that the best and the kindest thing that Anglo-Australian people could do to our people was to smooth out the dying pillar. So this was a problem that was going to disappear in a very short time, and therefore was not something that the Federation had to worry about in the long term. So we come to 1901 and the Constitution takes legal effect. And as most of you know, Aboriginal people didn't disappear. Their cultures have remained strong. They have been hugely and adversely affected by law and by society, but nonetheless have survived not completely intact, but as with any human culture, as an evolving community, evolving into different groups, but nonetheless very strongly identifying as the First Nation people, not as Aboriginal, because the term Aboriginal itself is a post-colonial term. Torres Strait is named after a Spaniard. If my great-grandmother was told that she was Torres Strait Islander, she would have been thinking that I drank too much or something like that. She wouldn't have known what on earth it meant, because that was not what she would have called herself. But these people have survived, and they have survived very strongly, and are now in a position to reassert their rights. And we have strong people like Sharon and her sister, who's a magistrate in Queensland. And we have judges, and we have people who now understand English law and understand our ways, and perhaps are in a better position to fight back in a sense. Not in a sense of fighting and killing, but in a sense of asking for what is right and just. Not an inch more, not an inch less. As Aboriginal people united and created societies like the Native Societies and the Aborigines League and various groups, started to react to the harsh segregationist laws that applied to our people. And Anglo-Australia also started to react to this, saying, well, we can't continue in this way and we need to find some kind of accommodation. We can't continue to pretend that these people don't exist when they clearly do. Our children are marrying theirs, their children are marrying ours, we have intermixing, we have these people living among us. We have to do something about it. And you see the writings of the elders of the white community saying this. Paul Hasluck, Sir Robert Menzies, Sir Harold Holt, all of these people very strongly talking about the fact that something needs to be done. What this something is was, of course, a very difficult and vexed question for the community. Leading up to 1967 and after the Second World War, after the horrors of the Holocaust and the destruction of another group of people, and talking about that, I would like to remind my Aboriginal brothers and sisters that the opposition to Kristallnacht in Melbourne was carried out by a Yorta Yorta elder. The majority of white people in Australia, to the best of my knowledge and understanding, didn't oppose. I mean, they might have opposed it in their hearts, but they didn't go to the German consulate and say that this is an unacceptable treatment of our brothers and sisters in Europe. But it was a Yorta Yorta man, and the synagogue here in Canberra celebrated this gentleman, and his name is written there, but I will not mention it for cultural reasons. The world said, we can't do this anymore. And Australia, people who were very strongly involved with the Declaration of the Rights of Human Rights, brought these ideas back to Australia and said, we can't continue in this vein that we are at the moment by ignoring these people, not counting them as human beings. As a civilized society, we would soon be excluded from that body of civilized people if we continue this way. And in 1967, I mean, most of you know the history, two sections of the Australian Constitution were amended. Section 117, which said that Aboriginal people shouldn't be counted among the human population, was rescinded. So from henceforth, Aboriginal people were to be counted as part of the human population. And the second, which was a little bit more controversial, removed the subsection in the Constitution which says that Parliament could make laws with respect to a people of a race, to now include Aboriginal people. Now this was probably not a fabulous thing to happen, and Aboriginal elders were very conscious of this. They said, yes, we know this. Sir Robert Menzies said, no, please don't do this. Harold Holt said, don't do this. Don Dunstan said, don't do this. Because what you're doing is, in effect, giving power to the Commonwealth Parliament to now also make laws to your detriment, when previously they couldn't. But our Aboriginal elders, and, personally I understand exactly where they were coming from, though people might criticize them in retrospect. Of course, it's always easy to criticize in retrospect, but they said, well, they're doing this to us anyway. At least now we can take these matters to court if there are positive laws. So you can understand both sides of it. And so we have the federal parliament now being able to make laws with respect to Aboriginal people. And then in 1975, there was the Whitlam government, which recognised land rights for people in the Northern Territory. Of course, there's a lot of water that flowed under the bridge there to get to that point. And in 1981, three gentlemen in the Torres Straits had a land dispute, which they took to the Supreme Court. And I won't go into the history of it, as many of you probably know the Mabo cases. And the second Mabo case came to the federal court. Now, in 1972, there was another important case that happened in the Northern Territory. This was the case between Nabalco, which was an aluminium company, and the people of the Goa Peninsula about their land, and trying to exclude Nabalco from mining on their land. And the case went to the Supreme Court in the Northern Territory, and Justice Blackburn said, well, I do recognize these people as human. I do recognize that they're people who have law. I do recognize that these are human, civilized human beings in every way, shape and form. But at that time, the Northern Territory was bound by this decision in Cooper and Stewart, the case that I talked about before, which didn't recognize Aboriginal civilization. And so His Honour said that he respectfully had to defer to this court in the Imperial Court in the United Kingdom. So at least we had, in fact, a recognition of Aboriginal civilization. I mean, of course, this is all for the consumption of non-Aboriginal people. Aboriginal people knew all along that they were civilized. I mean, this is nothing new. But we have to work with the system that we have, I guess. In 1987, Australia passed the Australia Acts, which made the High Court of Australia the highest court in Australia. So we, very broadly speaking, no longer were able to go to the Privy Council. And what this meant for Aboriginal people was that the High Court in Australia could now overrule a decision of the Privy Council. This was not possible before. And so the Mabo case, as you all know, went to court, the second Mabo case. And in 1992, the High Court recognised at common law the existence of native title, that when Her Majesty acquired, in the High Court's language, acquired sovereignty over this continent. And remember, Aboriginal people have never ever conceded sovereignty. This is purely an English law view of the world. When Her Majesty acquired sovereignty, that her sovereignty was burdened by native title of the Aboriginal people. So this was the first recognition in the highest court that Aboriginal people, law, land, languages were to be respected to some degree. Of course, the High Court, being an Anglo-Australian court, reserved for itself the right to extinguish these rights of Aboriginal people. But at least it was a step forward. At least they recognised this. And I would like to remind you of an article written by one of our elders, Michael Mansell, a lawyer from Tasmania, who tried not to be too happy with this decision because he said the High Court gives an inch but takes a mile, which is, I think, a fair reflection of what happened. I mean, so you take the whole continent and give us back what you don't want, but at least you're giving us back something. So, he recognized that we were getting an inch, but that the society had taken for itself the larger part of the land mass. What this does is recognize Aboriginal people at common law. But what we need to remember is that the Constitution itself, which is the primary law of the nation, does not recognize Aboriginal people. And the issue of recognition, if I can raise with you, if you go to a shop and purchase something and you don't like what you purchased, you can, and the seller disputes that, you go to court. you can have your day in court, and the court will decide on the merits, whatever the case might be. However, you and the seller are both entitled to go to court. And the reason you can do this is because we have legal personality as individuals. The law recognizes you as a person. Now, for issues of treaty or issues of land, issues of personhood, Anglo-Australian law recognizes us Aboriginal people and Torres Strait Islanders as people, but the Constitution doesn't. And this is a fundamental step. Anglo-Australia needs to recognize, not for us, not for Aboriginal people who've always known we've been here. This is not new. This is not nothing new. But this is almost telling our brothers and sisters in the mainstream, hey brothers, please put on these glasses because you can't see me. But when you put these glasses on, I will appear. This is what recognition does. This is not for us. This has nothing to do with us, even though we will suffer or benefit from the impacts of the decision. In 1998, under the Howard government, there was an attempt to recognise Aboriginal people in the Constitution. I won't talk about the merits of it, but it failed. I don't think it was a satisfactory recognition. Recognition must be, it doesn't have to have legal effect as such. I mean, it always has, recognition has legal effect, but we don't need to put everything into the Constitution. The Constitution was never a document that had a lot written about rights and things anyway. It needs to be mere recognition, but only as a first step. This is a 1,000-mile journey on which we need to take steps along the way. It is not to rectify 200 years of disadvantage and oppression. It's never going to happen. It can't happen. These things will take time. But the first step in that 1,000-mile journey is recognition. This is my view. Of course, there are many Aboriginal people who take a very different view, and these are strongly defended, strongly understood, and passionately held views. The reason why I take this view is because I'm trying to work within the Anglo-Australian law, and because we need that double majority in Parliament, we need the Parliament to take a step that they can see is winnable, because being politicians, and rightly so I guess from their point of view, they're not going to take something that won't be supported by the majority. But what our brothers and sisters in the mainstream need to recognise is what you do, because your Constitution gives you the power to do this to us, we still have to live with the decisions that you make. So please do it properly, do it correctly, and do it in a just and fair manner. So we come to 2010, where there was a hung parliament, and the Greens pushed this issue, and so it came back onto the national agenda after its failure in 1998. And the Parliament has put together expert panels and created a series of reports which is to inform themselves about how this process can continue. And I think the reports have been very good, but the recommendations are really complex. And because of the double majority, they're unlikely to pass. Many Aboriginal people met in Uluru, and they also excluded a lot of people. For example, our parliamentarians didn't have speaking rights. So, they do represent some people, but perhaps not all the people. And they have come up with a series of recommendations as well, and they're going to produce a report which I think is not yet out. It's supposed to be out any day now. But I put to you that as a matter of a first step, recognition is a useful thing, because the Constitution of this country, which includes us as well, needs to recognize us. It needs to say, well, you are there, we wrote you out of this constitution and we need to rectify this issue. We need to acknowledge your existence. We need to acknowledge that you were the first people of this land. We need to acknowledge that you were people who had law and culture and civilization that cared for this country for thousands and thousands of years before the arrival of people from the Northern Hemisphere. And this is the least that the majority community can do. There is almost another 1,000 miles to go in this journey before our languages, our cultures, our spiritualities, our art, our ways of dealing with each other, our songlines are brought back from the brink of extinction. But that, I guess, should be left for another day, because I don't think the mainstream community can deal with all of these issues in one fell swoop. So thank you very much for your attention, and I'm happy to answer any questions that you might have coming up with this.
Thank you very much. Very interesting. I'm wondering, obviously the recognition in the Constitution and more broadly is very important sign of respect and of, and in a way addresses a small part of the overall injustice. But I'm wondering, beyond that, that as an outcome, what is the recognition might provide in relation to benefits or the role of Indigenous Australians in the decades and beyond? What do you see it as a pathway to something else more material, I think?
Yeah, as I understand the question, what does legal recognition do? So as I was explaining before with the issue of contract, what it does is enables Aboriginal people, whatever that might mean as a collective, to deal with the mainstream, whatever that might mean, as distinct groups of people with distinct interests and distinct wants and desires. To enter into a treaty, for example, treaty requires recognition, and you can see that in places like Victoria and South Australia, their constitutions, the state constitutions, have recognised Aboriginal people. They did it without any fanfare because they don't need referenda to do it. The Parliament can do it, and it happened very quickly and painlessly. Unfortunately for us, with the federal constitution, we have to go through this rigmarole to get something as blindingly obvious as the mainstream saying, well, there were black people here. I mean, that's a no-brainer. What's the problem with that? But the Constitution is a hurdle in this being achieved. But what we can do then is to look at the treaty processes that are happening, for example, in Victoria and South Australia. And the people there, the Aboriginal people, have got together and trying to decide for themselves. We need to work out for ourselves, what is it that we want protected? What is it we want? Is it economic needs? Is it social needs? Is it cultural needs? We are also citizens of this broader community, so economic needs should be taken care of by the general law. I mean, the fact that we have separate laws for Aboriginal people in the Northern Territory and places like that is a kind of apartheid, really. It's a shame that this happens. But, recognition is not going to solve any of that. But with agency being transferred back to Aboriginal elders and Aboriginal communities, Aboriginal people will be able to work out for themselves what they want along the way. It's very difficult for us to know today what people in 100 years would want. So we don't want to entrench things, because what happens, like in the American Constitution, is they've got the right to bear arms, and this is an absolute mess. They're killing people willy-nilly everywhere. And that might have been fabulous 150 years ago when people needed to defend themselves, but today in Chicago, do you need to walk around with a gun? I don't think so. So, we need to be careful that we're not entrenching things, putting things into the Constitution and trying to regulate our children and grandchildren from our graves. We shouldn't do that. We should try and keep flexibility so that each generation can work out for itself. So recognition plus an evolving series of negotiations as we move down the track for each generation to work out what it needs, I think is probably the better way to do it. But there are other views, as I said. Yeah.
Thanks very much for your lecture, Dr. Wood. My question relates to a concept which I call the psychopathology of conflict. One particular aspect, blaming the victim. And I wonder, in terms of trying to get a majority of states, a majority of the population, it seems to me that there is still an overriding attitude of blaming the victim amongst certain sections of the media. A lot of the mainstream media, news organisations, for example, do not report on any refugee or asylum issue. It just doesn't exist for them. The shock jocks on radio, which are syndicated right throughout Australia, continue to provide messages of hate, hatred and discrimination unfettered, even to the extent of suggesting an Australian Prime Minister be put in a chuff bag and dropped out to sea, and they're still broadcasting. So in this increased atmosphere of hate and that psychological aspect of blaming the victim, what kind of strategies can the Indigenous community adopt in terms of one of the main tasks, and that is that public relations task in society, in media, in having people try and reach out to those people who don't want to know, who only want to blame the victim?
Thank you for your question, Elder Harry. This is an unfortunate reality with which we have to live with, and this is the problem with the referendum. We need a majority of these people to vote in the affirmative for any kind of recognition. I mean, to me, the negative, if they refuse to recognise our existence, I would question their humanity. I mean, what kind of people are you that you can't see us as human beings? What's wrong with you people? I mean, what is really wrong with you that you think that I'm not a human being, that my children, my brothers, my sisters are not human beings? What is it in you that refuses or stops you from recognising the humanity of another group of people? But nonetheless, we have to deal with this. And so a simple question is perhaps the only thing that will get through this majority. Just recognise us and let the negotiations happen down the track. From what I see of Aboriginal communities, most of our communities are struggling, but quite a few of them are very strong economically, culturally, socially, and are exercising their sense of self-determination. And I think large groups like the Wiradjuri are looking at bringing back language, are bringing back culture, and doing amazing things. Narrandjeri in South Australia are working through contractual processes to bring back. The northern communities are a little bit more intact and have language. And so we need to build on that. Not all groups are in the same position. So, and I think this issue of self-determination, where groups that have been self-determined for a long time, for centuries, can now get back together again and have the resources to continue that process of self-determining, would be the way I think we would survive and continue to flourish. But in terms of the law, it's a tough battle. It's a tough battle, and I think some kind of treaty in a broader sense would help it. Sorry, sis.
So I was just going to ask, picking up on that last point about the legislative process that hopefully will evolve towards accelerating this recognition process. Are there a lot of parallel developments going on in terms of the Aboriginal community itself, right throughout Australia, to try and drive that process in terms of interaction, not only amongst your own people? I'm a Pacific Islander, and so I was just curious about this, as to just how much interaction is going on right now on the ground and building into the various aspects of the community to help that process
There's a lot going on, I would like to say. I mean, as a lawyer, I see, my brothers and sisters who have got into the law and who now understand the law. Malcolm X said to us, the English language and the English law are the tools of our oppression. This is what he said about African Americans. And I think the same applies to us. And we need to understand the English language and the English law to help us, not to oppress other people, but to protect our own rights. And access to universities and access to education has helped our people to negotiate from a position of equality, if not of strength. The southern communities who have been much more impacted by colonialism, decimated, and they, Wiradjuri, Ngarrindjeri, Gunditjmara, these people are coming back so strongly and in an amazingly kind of, you look at them and you think, this is the strength of our people, and they are doing it, and we can all do this. So there is a precedent, and I think there is a strong move to come back. And personally, I'm very hopeful. So my sister at the back there.
Many African people are suspicious about the Recognise
Yes.
campaign, and I think, to use your own terms earlier, see it as another way, at least in this instance, a government-driven way of giving us an inch to take a mile.
Yeah.
Can you tell me what you consider are some of the possible disadvantages of us being recognised in the Constitution?
I share your skepticism, sister. The reason I engage with it is because we have no real choice, But is this my first option? No, it's not. I don't need anybody to recognize who I am. I don't really care, to be honest. If you don't recognize me, well, tough luck to you. You really couldn't give a toss. But unfortunately, in the society we live in, for economic reasons, we need to engage as communities. Do I see any disadvantages? The answer I'll give you is there is no, because they're doing what they want to do anyway. It makes no difference. They can make laws that are detrimental to us. They can make laws that put us in prisons. They can make laws that take away our lands. Everything is possible. So there's nothing that will change. But I think recognition will give us the opportunity to enter into treaty with the Commonwealth and to have people who we trust within our communities. And not just blind trust, we need to have accountability to make sure that the people who represent us are working in the best interests of all our communities. And this is a very hard thing to do, but this is something that we have to resolve for ourselves. How do we do it? I don't know. People like Tony McAvoy, who was the first senior counsel in our legal system, in the Anglo-Australian legal system, is setting up a group of consultations with various communities. Of course, as you can imagine, this is a very difficult thing to do with such a broad, huge country such as ours. But he's trying his best to bring as many diverse opinions as possible so that what goes into a treaty will not be... A treaty is any document. I mean, a treaty that says, yep, you can have whatever you want, I don't want anything back. That's a treaty as well. But that's not the kind of treaty we want. We want a treaty that is much stronger, that is much more affirmative, that cares for our languages, our people, our cultures, and keeps us strong and helps us to recover what we have. So a treaty that is not a treaty like in the United States where they're treated as second-class citizens under treaty, but a treaty that comes from a position of strength. So to answer your question, am I suspicious of the process? Absolutely, because we have it affects us, but we can't change the outcome. So why would I trust a process like that? But will it be detrimental to us? No, because the Parliament can do whatever it wants to us now anyway. And if we have recognition, we can go to international bodies, which are also quite big, but that's the best we have, I guess. Yes.
You talk about the differences in ways of life, understanding life and cultures. Now, I wonder, do the Aboriginal languages understand the Anglo-Saxon or the existent law and legislation, or can it be the legal terms translated into Aboriginal language, as being the Universal Declaration of Human Rights translated into some of the Aboriginal languages, or can it be done because of the differences you talk about?
So the question, if I can reframe it, the question is about how do we engage with the different laws given the problems of language. So we have in international law and in domestic law an area of law called the conflict of laws, which enables one legal system to talk to another. So for example, if you take European continental contract law, the formation of a contract doesn't require what we call consideration under Anglo-Australian law. Under Australian law, you require consideration. However, a contract that is entered into between an European and an Anglo-Saxon country is still valid at international law because we have mechanisms for translating it. So those same mechanisms will exist for translating Aboriginal law and concepts into English or international law terms. I don't see that as a problem. The notions of law, the notions of being fair, the notions of justice are very, very strong in Aboriginal cultures. So we will have no problems. I have no authority to speak on behalf of Aboriginal people, but I think this would not be an issue.
I can understand that, but can the language take it as well? The language do, you know?
Oh yes, absolutely. Absolutely, yes. Yeah, there's
Can we make the final question as we're over time?
Oh, sorry.
Last question. Thank you very much. Well, thank you, Dr. Wood, for your basically taking us from the history to the legal sphere. I want us to sort of shift perspective, looking at the same thing, but now from the Australian constitutional point of view. Let me first go to the politics of it. There's not an event that I have gone to where anybody of any standing who has come to give a talk or a lecture or has participated in an event has not started by first acknowledging that they meet on the lands of the Aboriginal people. They have invariably paid due acknowledgement and respect to the elders of the people, past and present. In your view, is this just political lip service? Or is there a true recognition of the fact that this land was indeed that of the Aboriginal people, and that's where they are standing? I ask this question because if that is the case, then I really wonder what is standing in the way of this majority Australian nation making the change that is necessary in the Constitution. The second part of my question would be the word recognition. That is critical. You recognize a fact, something that existed. You do not create a fact. You do not, by saying that you are a human being in the Constitution, would not now make you a human being. But by recognizing, it would recognize the fact that you are a human being. Consequently, what are the fears that may be politically present today that stand against that change being made in the Constitution?
So the first part of the question is about the acknowledgement of land that happens in most public meetings. I can't speak for the majority community because I don't represent them in any way, shape or form. But I would ask, the question I would ask is, if you mean what you say, why can't you recognize this at law? It's a simple question. You know, we have this issue of, you know, you think our people are rightly skeptical about this. You talk about this all the time, but you refuse to put it into your law. Why are you afraid to do that? Why are you afraid to say in your constitution that we were here, that we are people? The second question is about the constitutive versus the declaratory theories of law. So the common law is a declaratory kind of law. It says it discovers the existence of something that's already there. So recognition of Aboriginal people would be like, as I said before, them putting on their glasses and saying, oh, yeah, sorry, I didn't see you without my glasses, now I do. It's as simple as that. It doesn't create our existence. It acknowledges what was de facto existing already. So, thank you.
The whole purport of my questions is that there is nothing standing in the way.
No, there isn't.
There is the will, if we were to take it on face value, there is the political will to do it. So what is standing in the way?
I think, it's politics. The two sides of the multi-party agreement needs to be present on a question before it can be put to the people. So it's an issue for Parliament. As soon as they agree, it'll be a no-brainer. I think we'll have 1967, 95% of people voting against. The 6% who vote for Pauline Hanson might vote no, but I think the rest of the people will vote yes.
Thank you very much.
Let's